Thank you.
Justice Barrett. Justice Jackson.
So I guess I'm trying to puzzle through whether or not there is some independent form of discrimination against transgender women that is distinct from the sex separation that Title IX allows. So I appreciate that your argument is that because the regulations permit sex separation and that hasn't been challenged, that should be the end of this inquiry, basically. And I think you get there because you say you're sort of picking up on this idea that maybe this is just about a definition of who is a male or a woman. Is that right?
I think to some degree, but it's also, Your Honor, it's just because we're indifferent to a person's gender identity in applying the law.
But the law actually operates differently, I think, for cisgender women and transgender women. That is, with respect to their desire to play on a team that matches their gender identity, cisgender women can do it, transgender women cannot. And so we do appreciate a distinction, I think, that is being drawn on the basis of your gender status, gender identity status, trans or cis, right?
So, and I want to make sure I understand
Yes.
if we're operating in Title IX world or equal protection world, because I think it might make a difference to the answer. But
okay, let's start with Title IX.
So Title IX, I think the question of, I look at this statute and see a distinction between boy and girl indifferent to gender identity. And I think that...
Right, but I'm testing that proposition, right? You see that distinction, and I see it too on the separation of teams level at the beginning.
Right, and I think what I'm hearing is that distinction arises from a difference in effect, and I don't see a disparate impact analysis that's sort of hidden away in Title IX.
But why is that a difference in effect? So it's like a second order discrimination, right? The first order is separating male from female.
Right.
The second order is separating transgender women from cisgender women, right?
Respectfully, I would disagree,
No.
Your Honor. The reason why is just because I think anytime you have a classification, you could divide it into subclassifications, and I don't think that then becomes, like, the law in the same way applies to brown-haired biological girls and blonde-headed biological girls.
I understand, but I don't think you can get,
based on hair color.
I'm not sure, and maybe this is switching to the equal protection, I don't think you can get out of the implications of making a classification by setting it up as a definition. You know, as a subclass, and so we've already okayed the classification because it's really all about classification. You can't distinguish in that way, right?
Well, I think what the court said on the equal protection side is you look at the facial classification, and I think here it's effectively unconceded that the facial classification is between boy and girl. And I think at that point, if maybe you have a situation where you think that the classification is somehow a proxy for some sort of secret secondary classification, but I don't hear them suggesting that.
The definition implicates another division. So here's an example. So suppose that we have Title IX exempting, and I think it does this, certain religious institutions from its requirements. And let's say Title IX then went on to define, this is in my hypothetical, religious institutions to include only those institutions that proselytize. I mean, is that a classification problem or a definition problem? I would say it would be a classification problem, and you'd still have to apply all of the heightened scrutiny just because, you know, they're defining religious institutions in a certain way. Similarly here, you have the overarching classification, you know, everybody has to be, play on the team that is the same as their sex at birth. But then you have a gender identity definition that is operating within that, meaning a distinction, meaning that for cisgender girls, they can play consistent with their gender identity. For transgender girls, they can't.
So I think that, okay, so as to the part about your ability to pass over from boy to girl, where
yes,
you can go from one way but not the other, I want to be clear that B.P.J. is not challenging that specific classification. I think that's important to start with. But I think, if anything, that's useful evidence as to the lack of a transgender-based discrimination, because if the legislature were just sort of unsettled by the notion of transgender athletes, I think the answer would have been to then bar them from
No, I
passing over
appreciate
anyone
that.
inconsistent with their gender.
I appreciate that. I guess I was getting at the, what I understood the Chief Justice to be trying to
Right.
discuss, which was this notion that this is really just about the definition of we accept that you can separate boys and girls, and we are now looking at the definition of a girl, and we're saying only people who were girl assigned at birth qualify.
And there is authority cited in our brief. This court, I don't think, has ever phrased it quite as in the way of this definitional framing that we're talking about right now, but certainly cases like Jana Rock in the Second Circuit do approach it from this sort of definitional framing, and they say that if you effectively concede that there's an initial ability to draw a classification, then that suffices to satisfy the intermediate scrutiny question. But then past that, the definitional question is evaluated through rational basis review, and that's Jana Rock. I recognize this court has never gone as far as that, but I don't think the court needs to go as far as that because, again, I think the way that you would do the analysis is to start by looking to the face of the statute, and if the face of the statute is engaged in a conceded boy-girl sex classification is conceded to be legitimate, then at that point, you kind of know which world you're operating in.
Thank you.
Thank you.
Thank you, counsel.